Hello everyone, welcome to CLAT 1. Today we'll be starting with legal reasoning, and our first topic is going to be one of the very basic topics of the law of contract, which is the essential of a contract and the four main pillars of a contract. Okay, so let's get into it. So first of all, what is a contract? First, we already know what an agreement is, that anything that you agree upon with someone is an agreement. But a contract is not exactly an agreement. It's an agreement which has legal enforceability. So, for an agreement, for example, if you are in an agreement with your father to go to a movie, you cannot sue him in the court of law, saying that your father promised you, but he did not take you to the movie. Now, for a contract to be valid, it has to be legally enforceable, which means you can sue the person in the court of law. So, a contract is a legally enforceable agreement. This is a very basic. We'll get into the more detailed parts right now. Okay, so let's get into what are the essentials of a valid contract. So there are six main essentials of a valid contract. The first one is offer and acceptance, which means that a clear offer must be made and there should be a communicated acceptance. Okay, for example, A offers B to sell his painting for 2,000 rupees and B agrees to pay the amount, which means that A made an offer, sell the painting for a consideration of 2,000 and B clearly agreed to pay the amount, which is an acceptance. Okay. So the second essential is the intention to create legal relations. So as I already gave you an example that domestic agreements are not valid. For example, your father, promising you to take you to a movie is not a valid contract. You cannot sue your father in the court of law. A similar example is a football player signs a contract with a football team to play matches for them at a pay of 10,000 rupees per match. Okay. This is an intention to create a legal relation between the team and the player. If the player misses a match, he does not get paid 10,000 rupees. That is a legal relation. Okay. The next essential is lawful consideration, the price for a promise, which is cash, goods, services, or a promise in return. Example, when you buy something from a shopkeeper, you pay him in return money. Okay, so that is a lawful consideration. Anything without a consideration is not a contract. The next valid essential is legal capacity of parties. Okay, so there are mainly three things that decide that the person is capable to get into the contract. The first one is that he should not be a minor. He should be the age of 18 plus. He should be of sound mind and he should not be disqualified by law. Means the law should not have disqualified him from getting into a contract. If, for example, Sam, a 14-year-old, cannot legally buy a car because he's a minor. Okay. The next essential is pre-consent. So there should be no coercion, no undue influence, no fraud, or no misrepresentation. For example, Soham treating Abhinav to buy his car by putting a gun on his head. So Soham is coercing Abhinav to sell his car. Okay. So this is not free consent. So any contract without free consent is not a valid contract. The next is that lawful object. The purpose of the agreement must itself be legal. Asking a courier company to deliver drugs. So delivering drugs obviously is not legal. So a contract that is not legal is never going to be a valid contract. A similar example should be if I'm paying someone money to kill someone. It's not valid because killing someone is not something legal. Okay. Let's move to the next thing. Let's get into each of the essential. The first one is offer and acceptance. Okay. Let's start with the offer, a clear proposal made to another capable of being accepted as is. Okay. So if I'm telling someone that I want to sell my bike for 10,000, it is an offer, a clear offer which has consideration mentioned. 10,000 rupees is the consideration. So the offer must be clear and it must be from my side. If I'm trying to sell, it should be from my side. Okay. The next one is absolute acceptance. Acceptance must be mirror of the offer exactly. The mirror image rule. Okay. So this means that if I'm offering to sell my bike for 10,000, you cannot tell me that I want to buy a bike for 8,000 because that's an absolutely new offer. It's not the acceptance of the offer I made. Okay. So if I'm making an offer, you should accept the offer as it is. The next one is communication of the offer. Okay. So both offer and acceptance must be communicated to take effect. If I'm telling you, if I'm offering you via, let's say, speech, you cannot make up your mind that okay, I'll accept his offer of selling his bike, of buying his bike, but I'm not going to tell him. That's not valid contract because you're not communicating your acceptance. Okay. Now let's see the CLAT trap. So general offer like reward poster can be accepted by conduct. Now this is something which is not exactly coming into the ambit of communication. Okay, so you'll read it more about when you get into law school. So anyone who finds and returns a lost dog under a reward poster has validly accepted even without replying to the post. He has not communicated to the person that I'm going to find your dog, but because if he finds his dog, it's by conduct he's accepting the offer. Okay, let's move to the second one, which is intention to create legal relations. The presumption rule. Domestic and social promises are presumed to lack legal intent. Okay, the same thing. If I'm talking to my father, if my father promises me something, he'll do it for me, he'll get me something, and if he does not get, it is not a contract. I cannot sue him because it's a domestic agreement which we made. Okay, rebutting the presumption. Either presumption can be overturned without evidence. A written, signed, and registered family settlement dividing a property can still be legally binding. For example, um, you know, uh, uh, if me and my father, if we sign a legal document, okay, that I'll take you to movie, that is a legal document which I and my father have signed, and now I can sue him right now that you did not take me to movie because now it is on paper. It is a contract which he has signed. The next is why it matters. So without the element, even a fully agreed promise stays a moral obligation. So the example is promising to take a sibling to a movie if the study is not a contract, however sincerely meant. Even if you are very close to the person, if it is something very close to you or the person other than you, it's still not a valid contract because it is an agreement. You are not legally bound to take him to a movie. Okay. Let's see the CLAT trap for this, which is passages often dress up a family favor as a formal sounding deal or vice versa. Okay. So generally, if a family deals, like, for example, the one I gave the example of, these things they'll make it sound like they are a valid contract, but they are usually not because, of course, they are a domestic, something you talk with your father or your family. So it's not a legal contract, it's an agreement. The next one, let's go to lawful consideration, which is the price of a promise. Okay, so what counts? Consideration is cash, goods, service, or a promise given in return for a promise. Okay. So paying the shopkeeper money in return for vegetables is straightforward value consideration. If you buy something, you pay something in return, which is very basic. Adequacy does not matter. Consideration must be real, but quote, don't check if the bargain was fair. So even if I'm trying to sell my 10 lakh car for 1 lakh rupees, it does not matter because there is some consideration involved. Okay, so the courts do not see if the consideration is equal to the price of the good or not. There should be something in consideration. Okay, but still there is an exception. The section 25 talks about consideration, but there's an exception to the section 25, which is agreements need no consideration if made from natural love and affection. For example, if my father gifts me a bike, that's not a contract. He's gifting me out of affection. Okay, so it does not need an consideration for my father to give me a bike. The next one is the CLAT trap. Past consideration, a promise made after an act was already done voluntarily, usually does not count. So if I've already bought a bike 3 months ago, if I stole some bike, for example, let's take an example of stealing a bike. If I stole a bike and 3 months later I go to the owner and give him the money in return that I stole your bike 3 months ago, but now I don't want to take it, and now I let's see the CLAT trap. Past consideration, a promise made after an act was already done, voluntary usually does not count. So if I pay someone after I've already done something, it does not count. Okay, let's go to the next one. The legal capacity of parties. So I think it is one of the most recurring topics in CLAT legal reasoning. So who qualifies as someone who can get under contract? A party must be a major, which is of 18 plus age, of sound mind, and not disqualified by any law. Minors are absolutely barred from getting into a contract, and the contract is void ab initio, which means it is void from the very beginning. Okay, no, there is no exception to this that a minor can get into a contract. Now, unsound people of unsound mind also cannot get into a contract, but this is also not a permanent rule. A person's capacity to get into a contract is tested uh, when he's getting into a contract. If at the time of the commencement of the contract, if he's in sound mind, he can get into a contract. But if later on, if he's in unsound mind, of course he cannot. So if a person who sometimes gets either attacked, for example, can get into a contract when he is of sound mind. Okay, let's move to the next one, which is free consent. Okay, so these are the four main topics which we will deal in free consent, which is the first one is coercion. So if I'm putting a gun to my friend's head and telling him, please give me your car, if I'm forcing him to give me his car, it is coercion. I'm coercing him to sell me his car. Okay. And any contract made under coercion are not valid. The next one is undue influence. Dominant party abuses the position of power or trust. For example, a doctor. Let's say, example, a doctor. A doctor pressures a client to, let's say, gift his property. So the patient obviously needs the doctor, but the doctor is pressuring him to give his property in return of treatment. This is undue influence. He is using the his position here to get influence from the party. Okay, so any contract made under this is also not valid. Next is fraud, deliberate deception to induce consent. Okay, which means selling a car knowing its odometer was rolled back. I already know that the car is not in a condition to be sold, but I'm still selling it. This is fraud. And the misrepresentation. So misrepresentation and fraud have a slight difference. Okay. Misrepresentation, let's say here is a seller honestly but wrongly states a plot is litigation free. So I believe that the plot was litigation free, but actually it was not. So fraud is made with ill mind, and misrepresentation is generally not made with an ill mind. It's just that you are not aware about that. Okay. Let's move to the next thing, which is lawful object. Okay. So the purpose behind the deal must be clear as of the payment itself. The purpose is the object of an agreement must be not be forbidden by law, fraudulent, or against public policy. So anything that I'm trying to get contracted should be legal. I cannot pay someone to kill someone because it is not legal. Okay. Object versus consideration. So it is not important that if you have a consideration into a contract, it can be made a contract. Okay. So consideration is what is paid. Object is what the deed exists. Both must be lawful. If the consideration is lawful and there is no lawful object, there is no contract. Okay. So you need both object and consideration to get into a contract. Not voidable. Now, uh, a contract that has not got an lawful object is always void. It's not voidable at the option of the parties. That kind of contract is void from the very beginning. Now, let's see the CLAT trap. Lawful payment does not rescue an unlawful purpose. Example, asking a courier company lawfully paid to deliver drugs, unlawful object, fails an object alone. If I'm paying a courier company a consideration to do something that is illegal, obviously that is not made with a clean mind, and you cannot get into that kind of contract. Next, we are going to see the four pillars of enforceability, which is valid, void ab initio, void, and voidable. Valid is everything, all the six essentials are fulfilled. Valid. Nice. Next is void ab initio. Void ab initio contracts are contracts that are invalid from the very beginning. For example, one which we saw that any minor cannot get into a contract or the lawful object one. Okay, so these kind of contracts are invalid from the very beginning. Void are which was valid, but they became unenforceable after a period of time. For example, if I got into a contract to perform at a let's say a music show, but later due to a flood the theater got destroyed, I cannot perform there. The contract becomes voidable is if someone was wrong, for example someone was influenced unduly or someone was coerced to get into a contract, that person can say the contract is valid, but they can also declare the contract void at their option. Okay. So this is the person who is wrong, who is injured, can cancel the contract. Now let's see the four landmark case laws. Obviously, we're not going to deal in detail these, but these are some cases that you should know that can come in CLAT, that come in paragraph forms. The first one is Mohori Bibi versus Damodar Das Ghose. Uh, a minor mortgaged his house to a money lender. So a minor cannot get into a contract. Okay. Next one is Balfour versus Balfour. Husband promised his wife a monthly allowance while abroad. Held domestic promises lack intention to create legal relation. Husband promised, but of course the wife cannot sue him in the court of law because of course that was a domestic contract, or domestic agreement. Sorry. Chinaya versus Ramaya. A mother gifted land to her daughter, directing her to pay an annuity to her aunt. Held the aunt could enforce it, considering consideration can move from a third party. The next is Ragna Kumar versus Albert Setti. A widow was forced to adopt a son by threat to obstruct her husband's funeral. It was held that the consent that is obtained by coercion, here the adoption was voidable. Okay, it was voidable at the option of the widow. Applying the concept, let's see how questions can be asked and glad to you. So, void ab initio. Let's see the first example of void ab initio contract. A minor coder, 16-year-old RF signs at 5 lakh app deal and spends the 2 lakh advance, can the company sue him? No, a minor contract is voidable issue. The contract is void from the very beginning. You cannot sue RF to get the money back. Okay. Next is void, the cancelled concert. Exactly the example I gave you. If I am going to perform, but days before a cyclone destroys the venue, the contract gets cancelled or void. Next is voidable, the coerced sale. Certain at gunpoint, Peter sells his 50 lakh rupees car for just 5 lakhs and signs a contract. He was coerced to sell his car. Now he can declare the contract voidable at his option. Now we'll see the litmus test. For any passive-based question, ask these three questions in order to know if the contract is voidable, void, or void ab initio. Did they have the basic capacity to contract? If no, then the contract is void ab initio. Was someone tricked or forced into saying yes? If someone was, then it is voidable. And the third one is, did an unexpected event or change in law make it impossible later? If yes, then the contract is void. So thank you for watching the video, guys. Subscribe to CLAT1 and stay updated. We'll be uploading more videos like these in the future. Thank you so much.